provision of our Oregon corporate statute, ORS 60.952. This particular statute was sort of a one-of-a-kind statute nationally when it was adopted in 2001 as part of the NATO family litigation. And although there's a lot of parts in the statute that actually come from other sources, whether it be from the common law as the Oregon Supreme Court had previously decided it, or the statutory provision we're going to be focused on today, this mandatory buyout provision, actually comes from the Model Business Corporation Act and has been part of that act since the 1980s. Our sort of subcommittee that drafted this proposed language for the group to consider was Aurelia, Kyle, Mosen, and myself. And we did that because this is an important statute in the corporate context that has never been part of Oregon's LLC Act. But in business litigation, a lot of corporate concepts historically in Oregon have been by default, if you will, sort of imported into the LLC litigation context because our LLC Act is in some ways, it just doesn't have so much detail. And also because sometimes people value this tool. And so I flagged it and Kyle and Aurelia as something that we thought this group should just consider. We didn't have a recommendation on whether we should adopt it or not. And as a group, the three of us and Mosen, who went over this language as well, we don't have a consensus on whether the group should adopt it or not. So it's really something that the group should consider. Aurelia leans most strongly among the four of us toward adopting this. Mosen is very much not thinking that we should adopt this because he wants us just to basically do ROLCA, and this would be a deviation from ROLCA. And Kyle and I are both relatively agnostic on it. As we discussed before, the concept of a forced buyout of a member who is bringing a dissolution proceeding based upon oppression or illegal conduct, that kind of stuff. The ability of the other members to force buy out that petitioning member has some pros and cons. Some of the pros include that it can reduce the cost of the litigation, and it can also reduce the duration of the litigation. It can reduce the friction that the litigation causes both among the members as well as for the company itself and its own ongoing soundness. Some of the cons are, in particular, a lot of times with these businesses, the members are not only deriving a benefit on account of distributions, oftentimes they also derive a benefit from salaries and also maybe a managerial position at the company and things like that that may be as important or more important to them than the distributions. And so getting forced bought out under this statute, they're going to get paid for the sort of the value of their shares, ostensibly based on future expected distributions, but they won't really get compensated, at least not in the same way, for their salary that they're going to be foregoing or loss of management role, things like that. So there are some cons for the petitioning member, and maybe if their claim isn't meritorious, then tough. They haven't really lost out on much. But if they do have a meritorious claim and they're not even going to get to litigate the merits of that claim to get bought out for something that's less than what they would on their own in a free market transaction, they wouldn't sell it for that price. So there's that aspect of it. That's a con. There may be additional pros and cons to adopting this for the Oregon's LLC Act, but I wanted to at least mention those for the group's consideration. No other state has adopted this for the LLC Act. And also you'll notice it's not in ROLCA, even though this concept exists and has existed in the Model Business Corporation Act for decades. So I don't say that to weight the discussion one way or the other, but just to have the group be informed. But the group was interested enough in exploring this concept at our last meeting that it asked us to come up with some proposed language. So what has been circulated to everyone is proposed ROLCA section 807, which takes, it's got sections A and B here. Section A is essentially 60952 sub 6, and then part B is essentially 60.952 sub 5. 6 talks about the process by which the other members or the LLC itself can force buyout the member who has been filing the dissolution proceeding. And then subsection B, which is 952 sub 5, talks about how you determine the price at which this forced buyout will occur if the parties can't agree on that price. Just before I start going through our version in more detail, I wanted just to mention briefly, so you all have a concept of 6952, what its structure is. And because some of those provisions are brought into our proposed section 807. Under 6952, sub 1 talks about in closely held companies, which is defined as all non-publicly traded corporations, they if a member, it says that a member can sue for dissolution if there's deadlock, waste, oppression, list a few different grounds. Those are the main ones. And if under sub 1, a member brings a dissolution proceeding for those grounds, this isn't in the document that's in front of you on the shared screen. Under sub 2, the court can award a variety of remedies, including dissolution, but then it lists 10 or more other remedies that are less than that the court can do, such as receiver, custodian, various other things, corporate management. Section 3 of the ORS talks about how the remedies under the ORS are not exclusive, and that some of those remedies can be curtailed in the bylaws. Subsection 4 talks about how the court needs to take everyone's reasonable expectations into account, minimize harm to the company. Section 5 talks about how the court can order the petitioning member to be, or petitioning shareholder to be bought out, and talks about what the process of that is. And then 6 is sort of the key part where it talks about how there can be a forced buyout by the other members. And finally, subsection 7 talks about how the court, if it hires a custodian or a receiver or an appraiser, it needs to compensate them from the company's funds. Okay, so that's the basic stuff. Looking at our proposed language here, we have, I haven't shown every red line that we have made to the ORS statute, but I have called out the red lines that you are not seeing on here. And in particular, you'll notice that every time they reference subsection 1 of this section in the ORS, that is the section talking about what are the grounds on which a shareholder can bring a dissolution proceeding. We have replaced that with a reference to section 701A4, which is the ROLCA provision talking about when a member can bring a dissolution action for an LLC. Likewise, we replaced corporation with limited liability company and shareholder with member. Also, every time the ORS talks about shares, we replaced that with entire interest. That entire interest language is something that we pulled from section 503F2 of ROLCA, which is the one that talks about when you have a single member LLC and there's a charging order against that LLC that gets foreclosed. Normally with a multi-member LLC, the buyer at that foreclosure only buys the transferable interest of the foreclosed upon member. But when it's a single member LLC, the buyer gets the entire interest of that single member, not only their transferable interest. That means in particular that the buyer gets the management rights as well as the economic rights. And because in this forced buyout scenario, we're not talking about having a member who maintains management rights after they've been bought out. They're gone from the company, just like in the corporate context. Once they've had all their shares bought, they are gone. And so we use the phrase here, entire interest. Mosen thought maybe using sort of the whole transferable interest would be sufficient. We as a group, you know, I mean, I and Aurelia, Kyle think entire interest is better. It just is, removes any potential confusion that this person who's being bought out isn't going to have any rights in the LLC after they've been bought out. So we used entire interest. So I didn't show that throughout here every time we make that change, but you know that we made that change.
So, so Cody, the language that we're looking at though says whole transferable interest, and it does refer to shares. I mean, the Sandy has up on the screen here.
Yes, so there are, so as my note up at the top there says, shares has been replaced with entire interest unless otherwise noted, because there are, and I'll explain those a couple instances where we do use whole transferable interest instead of entire interest.
Okay.
And I'll explain why we did that in those instances.
Sounds
in
good.
particular, those instances they're talking about other members' interests, not the selling member's interest.
Right. So just one thing before we move on, Sandy, can you give Cody the ability to move the screen so that and to share his own screen? Because I was getting kind of dizzy. It was going up and forth, back and forth, and back and forth.
That's a great call, Cody. I'm just going to make you a co-host.
Well, or you can just allow him to share his screen by going down to share screen.
I mean, if I'm just moving scrolling Sandy's screen, that works for me. I don't have anything different I'd be putting up anyway.
Okay, whichever way. I just want to be able to look at the section that Cody's talking about.
Sure. Well, I'm going to talk about A right here that you're looking at.
Valerie, I'm listening. So at this point, now that I know he's on this section, I'll just keep up with it.
Okay, but yeah, so Cody, go ahead and direct Sandy to move it if.
Okay, thanks. So A here, just that first paragraph talks about after a member files a dissolution proceeding, then, and again, this is for a non-publicly traded LLC, at any time within 90 days after that proceeding is filed, the LLC or one or more of its members can elect to purchase the entire interest, not only the transferable interest, owned by the member who filed the proceeding for its fair value. And then it talks about how that election needs to be made in writing, stating the amount they're going to pay for the entire interest. And then there's additional rules we'll get to in a minute. I wanted to make a couple comments about this opening paragraph. For one, you'll see we added this big section of language that talks about how it only applies if the limited liability company does not have shares that are listed on a national exchange and so forth. That language is cut and paste from 6952 sub 1, which provides in a proceeding by a shareholder in a corporation that does not have shares that are listed on a national securities exchange or that are regularly traded in a market maintained by one or more members of a national or affiliated securities association, the circuit court may order and so forth. So we just took that language and put it in here because in the ORS context, that concept that this only applies to non-publicly traded corporations is sort of already at issue. It's already been stated in subsection 1. And so here we needed to state it in here. And then again, we used entire interest, not only the transferable interest, just to make clear that it's the management rights as well. And in this first time talking about entire interest, we added the additional, just clarifying language, not only the transferable interest. Again, that language comes from section ROLCA section 503F, where they say that when you foreclose a charging order on a single member LLC, you get, quote unquote, the member's entire interest, not only the member's transferable interest. So that's why we put that in there. And then for its fair value. Fair value is been established under the Oregon corporate statute it's not fair market value, it's fair value. And the main difference being in fair market value, you would discount the value of the shares, or in this case, the membership interest, on account of its lack of marketability because it's a privately owned company, and also on account of its minority status. Usually it's not the majority member or majority shareholder who's bringing the claim, but they're a minority owner, and there's an additional discount usually provided for that. Fair value, you don't do those two discounts. You just do, you would run the traditional market analysis where you make those discounts and then you remove those discounts. That's how usually the experts value these things. And so, we'd be incorporating those concepts from the corporate statute into our LLC version. And one other thing I wanted to note is that we're talking about a proceeding brought under section 701A4. The causes of dissolution described in 701A4 don't entirely match up with the causes of dissolution for corporations mentioned in ORS 60.952. Both allow dissolution when in the corporate statute it says the directors or those in control of the corporation have acted, are acting, or will act in a manner that is illegal, oppressive, or fraudulent. And ROLCA 701.4 talks about the people in control of the company acting in the manner that's illegal or fraudulent or oppressive. So they talk about those things. So that's the same. The corporate statute talks about if the directors are deadlocked and the shareholders are unable to break that deadlock, and there would be irreparable injury to the company, or the business and affairs of the corporation can no longer be conducted to the advantage of the shareholders because of that deadlock. There's not a direct analog of that in ROLCA, although ROLCA does allow dissolution when it is not reasonably practical to carry on the company's activities and affairs in conformity with the certificate of organization and operating agreement, which does reach some of those same things the corporate statute talks about. The corporate statute also talks about just the shareholders being deadlocked, or if there's waste, corporate waste. Those are not in ROLCA. ROLCA alternatively talks about when the conduct of all or substantially all of the company's activities and affairs is unlawful. Rather than add additional grounds for dissolution to ROLCA for waste or deadlock, we thought it's best just to leave ROLCA 701.4 as it is, which is what we did when we already covered that section, and just have this concept of a forced buyout apply when there's a dissolution under ROLCA, and rather than add deadlock or waste, which are grounds for corporate dissolution. We just wanted to flag that. That was sort of a choice we made here. But if people feel that we should do something different, obviously that's something that we can talk about. Let me see, make sure I didn't have any other notes on that. I can also, just if people have any questions before I move on. Sorry, I've been talking for a long time. I'll if there's any.
I have a small one, Cody.
Yeah.
I have a small question on the third line of A. Shouldn't it reference interests rather than shares?
I think
yes, it should.
Aren't publicly traded partnerships, because that's what we're talking about here, right? Don't they have sort of share equivalents? I've never done a lot with them, so I don't know.
Often use the word units.
I know we use the word units generally, but when they're listed, what are they listed as?
I don't know that it's mandatory that there's a specific nomenclature that gets used, but I was just thinking interests would be consistent with the rest of ROLCA.
Yeah, that's fair.
I think that's right. At minimum, it's something that I should have caught and fixed when we were doing this. So I will flag that for myself right now and have that. I'll write down interests.
Yeah. One thing, Cody, that occurs to me listening to you explain this is that the operating agreement that they may have an option to purchase under certain circumstances for fair market value. And that takes into account discounts and things like that typically, right? And so it's usually structured to be done in a way that is more favorable to the company, the terms that are more favorable to the company on a buyout of a member. But here, we have a incentive for someone who wants to get bought out to bring an action, because they would, if the option is exercised, they're not going to be not going to be subject to those discounting rules that they may have in the operating agreement. And I wonder if that's an incentive for litigation. So if I'm a member in an LLC and I, want to get out, and I think that they would want to buy me out, if I bring a dissolution proceeding, does that incentivize me to do it?
I don't believe so, and I'll tell you why.
Okay.
There's two reasons. One is nothing in this statute, this proposed section 807 prohibits the operating agreement from having its own contractual buyout provision.
Mm-hmm.
You can have whatever you want in that. For two, as part of our proposal on this section 807 is to add a new subsection to 105C to say that the operating agreement may not, and now I'm going to quote what our proposed new language is, may not vary the provisions of section 807, but the operating agreement may provide that the company and the members will not be subject to section 807.
Oh, okay.
And so by this would specifically authorize the operating agreement to just nix this whole concept of the forced buyout if they want to. And we took the basic concept of you can do 807.
Please mute.
We took the whole concept of you can either have 807 apply as it is and not vary it, or you can not have 807 apply from how ROLCA treats the Special Litigation Committee, which is a concept we decided not to adopt, and therefore we didn't adopt the part of 105C that talks about that. But ROLCA talks about the Special Litigation Committee, and it says you can either, in your operating agreement, you can say we're not going to have Special Litigation Committee, and that's your choice, that's fine. But if you're going to allow Special Litigation Committee, then you can't vary the ROLCA provisions about how those committees operate and what powers they have. And so we thought we kind of incorporated that concept here with regard to the forced buyout.
So Cody, when I was looking through this morning, I wondered how that would actually play out in negotiated operating agreements, because right now somebody could adopt something like this and provide for fair market value. They could set up this same process in an operating agreement. With your language, I'm just not clear. When do we know if someone is varying versus opting out? Can we opt out and put in our own buyout right? How do we know when we're too close to varying versus putting in something that we might already have the right to do, for example?
So for one, I think if you, under this proposal, if you had in your LLC operating agreement, section 807 of the Oregon, ROLCA doesn't apply, and then here's our contractual buyout provision, I would think that you've clearly stated your intention not to be under ROLCA or under this 807. And then whatever you say is, going to be the case. It's not going to be deemed an illegal varying of 807 because you've opted out. If somebody doesn't have that sort of magic language of we opt out of 807, then it may be a harder to tell, have they opted out or have they done just an illegal variation. But I think if you had that clear language, we are opting out, that would be sufficient. And I don't think there's any law on the Special Litigation Committee provision, how you can opt out, but you can't vary. But I would imagine that the case law that develops under that provision would be informative of what it is to opt out here versus have an illegal variance.
Cody, can I just add something that I think might be helpful, or maybe I think the reason for not allowing variance here is that the court is involved, and you can't contractually tell the court what to do. But if an operating agreement has buyout provisions that are different from these, even if it uses some of the concepts in these, and whatever conditions allow under the operating agreement those provisions to be invoked, then even if someone were to file a dissolution proceeding, the other parties, the other members could invoke whatever provisions are available under the operating agreement, and assuming those are available under the circumstances, then the whole thing would proceed under the operating agreement. It's really it's the members who are buying out that have the choice would have the choice under this provision to invoke the buyout under the court proceeding. But if there's so you could have a scenario where the members who are not seeking dissolution have an option as to whether to go with the statutory buyout proceeding, or use that process, or to use whatever the operating agreement provides for. So I don't think, I think that I see the concern, but I don't think it would ever actually manifest. But I don't know, Cody, maybe you have a different view on that.
No, I think that's right. It's a what is the authority on which the purchaser is relying for their right to purchase? Are they saying, I have a right to buy you out under the contract, or I have a right to buy you out because of the statute? Imagine that you have the person who doesn't have an operating agreement. Their only ability to do a forced buyout would be under the statute. If you have someone who has an operating agreement, they're going to be saying, I'm buying you out under our contract. I'm not relying on this statute. And so these statutory terms don't apply to me.
So I like the result that you two are describing. I think there's a risk that a court could say, let's say we draft a buyout right that's triggered by the filing of a lawsuit. I could see a court saying, well, look, this is basically trying to end run around this new rule. You're varying, you're not replacing. My suggestion would be to be express about that, to add a sentence somewhere that says, you're not varying this rule by adopting your own buyout right in the operating agreement, even if it may have similar provisions.
Okay, so it strikes me as that would be sort of a tweak on the addition to 105C that we would be adding here.
Yeah, but I support that. I think that if we go in this direction, I think it's important to tell people what order things go in, if that makes sense.
Yeah. Okay. Anything else? All right, I'll keep going here then. So A1, the election to purchase is irrevocable unless the court lets you modify it. Section 2, if the election to purchase is filed by one or more members, the LLC has to give notice to all the other members. And the notice is going to state the name of the petitioning member, the whole transferable interest owned by that member, and that instance probably should be the entire interest. The point being, everyone wants to know what percent do they own, and I think that probably should be the entire interest.
Yeah.
Actually, sorry about that, because that's what's being bought. The name of each electing member and the whole transferable interest owned by that electing member. And that's because people want to know, let's say the selling member owns 20% and the buying member owns 35% versus 25%. And you want to know, is this buyer going to become the new majority owner? Things like that. So it has to say what their interest is, and the amount that they're going to pay. And then it has to advise all the other members of their opportunity to join in this purchase. And they have to file a notice if they want to do that. And then they become parties to the proceeding. And they were going to participate in the purchase in proportion to their respective rights to share in distributions as of the date the first election was filed. The corporate statute, as you can see, it talks about they participate in the purchase in proportion to their ownership of shares. So it's a proportional thing. there's 100 shares in the company and you owed 10, then you're supposed to pay 10% of the purchase price. Whereas here we don't have shares, we have, you know, interests. And I took this language, our group did, from the respective rights to share in distributions. That comes from 707B2, which is a ROLCA provision that is talking about disposition of assets and winding up. And it says that after the LLC in the winding up pays off all of its debts, surplus is distributed in the following order. And it talks about to each person owning a transferable interest that reflects contributions made, and among persons owning transferable interests in proportion to their respective rights to share in distributions immediately before dissolution of the company. And it seemed to be that they were getting at a similar concept there of surplus money at dissolution is going to be paid to people according to basically what percent units do they have. And this reaches that same concept of, you know, if you own 10% of the company, you pay 10% of the purchase price. That's where that language comes from. Tried to grab something that was already in ROLCA rather than make up our own comparable language.
Can I ask a question?
Yeah.
So let's suppose you were the 35% member and you wanted to buy the 20% member share because you knew that would give you a majority. You would have 55%, and you'd be willing to pay more for that than you would be willing to pay if you were only going to get half that amount, because that wouldn't make you a majority owner. As I understand this, you make your offer as if you're going to get all of it, but somebody else then can come in and take part of what you want to buy and dilute you. Are you able then to readjust your price back down to decrease the premium that you wouldn't have paid a premium for the minority interest? You wouldn't have paid a premium to get 10%, but you would pay a premium to get 20%?
You can't reduce the price. Section 3, which is the next section, talks about how you can increase the price but not decrease it.
Okay, so I guess you'd have to start with your lowest offer. Okay, thank you.
That,
I've never done this, so I don't know how it works.
Yeah, well, and there are, like, that is a question that may have come up in the corporate context, and probably, you know, whatever has been done or whatever court decides would be right in the corporate context would be the same in the LLC context. Yeah, you can't, this is an offer, and it's like a forced offer, but the buyer doesn't have to, or the seller, I mean, you know, the petitioning member doesn't have to accept this. If they don't, what we'll do is, as you'll see, we'll get to section B, which is where the court determines what the price is going to be. So this is sort of an opening offer from the buyer or the coalition of buyers to see if they can't reach an agreed upon price.
Okay. So this is not you make a final and best offer and you're stuck with whatever you say. This is just where you start.
That's right.
Okay, thank you. That's helpful.
Yeah, so then Sandy, if you could please scroll down a little bit, and we'll talk about sub 3 there. It talks about how the court in its discretion may allow the LLC and members to file an election basically for a higher price than previously offered. And if the court does so, then everyone gets a chance to join in at the higher price if they still want to, or if they hadn't decided before, but now they do want to join in. And again, it's all proportional. Section 4, after an election to purchase has been filed, then the case can't be settled. The petitioning member seeking the dissolution can't sell any part of their interest unless the court thinks it would be a good thing to do. In considering whether equity exists to approve any settlement, the court may take into consideration the reasonable expectations of the members as they existed at the time the LLC was formed and developed during the course of their relationship, including an existing agreement among the members. As you can see, the part I deleted there was as referred to in subsection 4 of this section, which is talking, that's the ORS. Subsection 4 says, and I'll just read it. In determining the appropriate remedies to order under subsection 2 of this section, which in the corporate context is talking about the various remedies short of dissolution that the court can order. In determining the appropriate remedies, the court may take into consideration the reasonable expectations of the corporation's shareholders as they existed at the time the corporation was formed and developed during the course of the shareholders' relationship with the corporation and with each other. The court shall endeavor to minimize the harm to the business of the corporation. So you can see we plugged that language in here into the LLC version. That last sentence about the court shall endeavor to minimize the harm to the business of the LLC, it may or may not be necessary to include here. It certainly seemed harmless to include it here. And in talking, the court here is deciding whether to allow the petitioning member to sell their interest sort of on their own, voluntarily to some third party, and whether to settle or not, and whether to approve a particular settlement. So it seemed like minimizing harm to the LLC made sense in this context, regardless whether it is sort of specifically necessary to describe the concept of the reasonable expectations of the members. If within 30 days of the filing of the latest election to purchase allowed by the court, if they can reach agreement, then boom, you've got a deal. That's what's going to happen. The court's going to enter an order to that effect. F, if the parties can't agree on a price or the terms, basically of the sale, then anybody can say, court, stay the proceedings. We need the court to determine the value here of the interests. And the court always will do that, basically, as a matter of practice. They always stay the proceedings, and you're not actually doing a dissolution proceeding anymore. It's a forced buyout at that point. And the court is then going to go under subsection B to figure out what will be the forced buyout price that the court is going to determine. And that is that subsection B. That is now, we're going to get into the language we have taken from ORS 60952 sub 5.
Hey, Cody, should E and F be relabeled 5 and 6? Aren't they A5 and A6?
Oh yeah, they should be. Thanks.
And then you have to fix, like in F, I think you have to fix some cross references.
Sure. Yeah. Well, yeah, at least one of them here. Yeah.
Yeah. In F, there's a cross reference to paragraph E that you'll have to fix too.
Yes. Yeah. Thanks. We only had 4 lawyers who were able to go over this draft before we shared it with everyone. So apologies for our errors, mostly all mine. So thanks, good catch. That's an excellent catch. So under subsection B, here's how they're going to do it. The court shall determine the fair value of the entire interest with or without the assistance of appraisers, taking account any impact on the value of the entire interest resulting from the actions giving rise to a proceeding. So this is that language is the same essentially as under the Corporate Act. Note that what it does do is it allows you to take into account basically the wrongful conduct of the of the majority member or whoever's being complained about. If there's a dissolution on account of oppression, for example, and the oppression has been hurting a minority member, but maybe the majority is trying to do a squeeze out by basically having the company not perform as well as it normally does in order to reduce the value of the minority members' interests so that they can be bought out on the cheap, and then the majority is going to start running the company full steam ahead as had been going on before. And this was all just an artificial depression and business success to force, to buy out some maybe cash-strapped minority member. well, that can be taken into account in determining what the fair value is, for example.
So Cody, then so the idea of bringing this into ROLCA or into our section of the code is to cut down on litigation, right? To give this sort of pressure valve for litigation so that we don't fight these things to the death, right? But I mean, won't we end up having exactly the same fight if we're fighting about it from a valuation perspective that we would be fighting about it from a, wrongful action perspective?
Sometimes so. There's a couple differences. One is this is a bench trial type issue, this fair value. It's not a jury trial. Also, and for example, some of the same discovery might be occurring, but not in every instance. This isn't an oppression-related dissolution matter. It may be essentially a deadlock related, and now we can't operate our company anymore under 701(4). And so there may be cases, and there are cases where these kinds of issues aren't arising anyway, but where they do arise, yes, some of the benefits of this forced buyout are reduced on account of the fact that you do take that into account in determining what is the fair value. That's true. And I don't mean to say that we shouldn't adopt this or that we should, but as I noted at the start, Mosen thinks we shouldn't do this, period. Kyle and I are pretty agnostic. Aurelia, I know, wants an opportunity to talk about after, when I'm done with this, then I think it'd be great if Aurelia has an opportunity to talk about why we should adopt this. And, again, I'm not against adopting it, but I'm also not going to give you the hard sell on it either. From my own personal, I think it's very reasonable to adopt this. I think it's very reasonable to say, we don't want to adopt this.
All right, well, we'll wait for the hard sell from Aurelia then.
But can I inject a point? Because probably what gives me the most heartburn is this B1 clause 1 or clause I. And I'm curious to what the group's feeling is. You notice it says with or without appraisers. So under subsection A, the parties could not mutually agree on the price. And so you're now into subsection B. And the court will determine the price with or without appraisers. That gives me heartburn. I mean, you've got judges that, often are coming out of the litigation side or the criminal side that are going to be sitting hearing these things. And how is a judge in a great position to determine the value of an LLC? I mean, the normal course is to go and use an appraiser.
Well, but Jeff, when the court does this, the way this works is it's a contested matter. And I don't mean that in the administrative law sense, but rather each party is going to have their own valuation expert who is going to, the selling member is going to say, no, the value, they're going to have an expert witness come and say the value is really high. And the buying member is going to have their own expert witness says, no, the value is really low. Neither of those people are going to be the appraisers that this B1 is talking about. The B1 would be a court appointed appraiser. That would be like where the judge says, maybe the parties can't afford their own business valuation experts. And the court says, I'm going to appoint, a court ordered appraiser, or maybe they each do. And the court says, I think both of these valuation experts are bunk, and I'm going to have my own appraiser do the appraisal here. And so that's not, the court isn't going to have no business expertise to advise about what the valuation of the company is. That just never happens. It's a litigated issue with experts on both sides, and the court basically almost never appoints an appraiser. This just gives the court the ability to do so if it thinks that it could benefit from having sort of an objective appraiser who isn't hired by either of the parties.
And okay, so what you're saying essentially is there's probably appraisers in the courtroom as expert witnesses for each side at a minimum.
Oh, typically. Yeah, that's exactly right. And this statute, and again, this is language we didn't come up with for the LLC Act. This is in the Corporate Act, and it just says that the court can essentially appoint an appraiser, just like they can appoint a special master or different thing, a referee, things like that.
Well, and that helps then. Maybe that takes away my concern. And the secondary issue I had related, but I think it's addressed with your response, as a lot of us know, there's the lack of marketability and minority interest discounts. And the question is, would they apply in a context like this? And the assumption is the two expert witness appraisers / expert witnesses would argue that. But I'm curious if anybody has any thoughts about those discounts that often apply in a context like this, and whether something should be expressly stated that you would apply the discounts or you would not.
That was the whole point with that first paragraph, though, right, Cody? Was that discounts don't apply.
Right. It says fair value, not fair market
Yeah, I mean,
value.
that gives me a little bit of heartburn.
And I think the
Well,
case
Jeff,
law is pretty clear that fair value, you don't apply those discounts.
all it means is if you want the discounts, you draft your own provision. That's all it means.
Well, that's one way to deal with it, yes, but let's assume in a lot of cases that doesn't happen and the statute itself is going to apply. And I'm with Valerie. It gives me a little bit of heartburn. This whole section gives me a little subsection, gives me a little heartburn, although Cody's explanation has helped. But fair value, you're saying those words do not take into account the discounts. And that seems odd to me that, you know, if you're talking about a 20% interest and we're just going to take the fair market value of the whole company and multiply it by 20%, and that's the purchase price, you knock out the discounts, and they should be considered, particularly lack of, the minority interest discount.
Oh, you and the IRS. So why don't we let Cody continue finish this, and then we can have a discussion on the overall merits or not merits of this.
Okay, I mean, that was the one place I had heartburn.
Yeah. No, I share your concern, Jeff.
Okay, go ahead.
Does anyone else have anything to say before I continue on?
You know, I did have one comment on the determining the value of the entire interest and use of appraisers. I think, Cody, what you're saying probably is true for the vast majority of these things litigated by lawyers. But I think that we do have to also contemplate the possibility that our plumbers have gone into business together, or maybe more likely two people have gone in together to buy a rental house and formed an LLC to do it, and they're having a fight. And you might not have an appraiser for that. You might have, you know, just testimony from the witnesses as to, you know, what the value of houses in that neighborhood are. And owners can testify as to value. That's admissible evidence. So I can imagine situations where you would not have expert witnesses on both sides. But I agree with you, it's not a lack of evidence on both sides. It still has to be admissible evidence of value. And what I hear you telling me is this phrase, with or without the assistance of appraisers, does not mean with or without the assistance of evidence of value. It just means the court can appoint a court-appointed expert appraiser or not.
Right. And I think your comment raises a couple of good points. One is this is the court deciding whether it wants to appoint its own appraiser. And it can do that if you have those two plumbers and they haven't brought any experts, and the court feels uncomfortable or uncertain about what justice it would be doing just by relying on those two say-sos of the plumbers, then it can appoint its own appraiser. On the other hand, if it feels like it has a pretty good feel for what the issue is and the parties haven't decided to, or they can't afford to hire experts and the court nonetheless feels it can come up with a just value, then it can just go ahead and do it. It doesn't have to do its own court-appointed appraiser. It can choose to do so. And since we're talking about the appraisers, I'll point out, you'll see down there at B1VI, B16, the court shall allow reasonable compensation to the appraiser for services rendered and reimbursement or direct payment of reasonable costs and expenses, all of which amounts shall be paid by the LLC. So if the court does feel like it needs to do a court-appointed appraiser, the LLC is going to pay for that appraisal. And it won't be, you know, either of the buyer or the selling member. That comes from ORS 60.9527, that language, which we just plugged in here because it seemed like a good way to plug it in. The other thing you mentioned is with regard to the plumbers, so we've talked a lot about carpet layers. With this section 807, if we adopt it, it will be the default rule for those carpet layers and plumbers. And it may be very well a good default rule for people to resort to this buyout principle As we've talked about with the language that we'd be doing in 105C, the more sophisticated parties who hire the Jeffs and the Jameses and the Valeries, et cetera, they can totally negate this whole concept and go their own contractual route. And so anyone who doesn't want to be doing this regime doesn't have to be doing it if they contract around it. And so I just thought I would throw that out because we've talked a lot about with different provisions wanting to make sure we take care of the people who don't have an operating agreement or don't have a sophisticated one. And then of course you can get around that. So I just thought I'd mention that. So in determining the value, the court determines they can have an appraiser if they want. They're going to consider financial legal constraints on the ability of the LLC or the purchasing member to do it. They're going to specify the terms of the purchase. Is going to be a lump sum, installments, is there interest, that kind of stuff. Then we're going to require the seller to deliver the seller's entire interest to the purchaser. They're going to retain jurisdiction to enforce the purchase order, including ordering the LLC to be dissolved if the purchase is not completed in accordance with the terms of the order, and then compensate the appraiser, as I mentioned. The purchase ordered under this subsection shall be consummated within 20 days after the date the order becomes final, unless the court or the LLC decides it does want to dissolve after all, which it can do. You'll notice there, instead of talking about articles of dissolution, I added the LLC Act language. After the purchase order is entered and before the purchase price is fully paid, any party can petition the court to modify the terms of the purchase. And unless the purchase order is modified, the selling member is dissociated as a member from the date the seller delivers the member's entire interest to the purchaser or such other date specified by the court. And the ORS talks about how the selling shareholder shall have no further rights. Here we talk about how they're dissociated, which is the more apt LLC Act language. And then I just wanted to, because that dissociation language is from section 6.0. So we talk about down below that we should, if we adopt this, we should amend ROLCA section 602.3. And 602.3 currently says that a person is dissociated as a member when the person's entire interest is transferred in a foreclosure sale under section 503F. That's the foreclosure of a charging order on a single member LLC. And then we would say, add in, a person is dissociated as a member when the person's entire interest is transferred in a foreclosure or in a purchase under section 807, so that make clear that you're dissociated in that context as well. And then just because it references that, or just because it raises this issue, section 603 of ROLCA talks about if you're dissociated, then you lose your management rights and your duties and obligations under section 409 as a member end with regard to everything that happens after you're dissociated. And any transferable interest owned by the person in the person's capacity as a member immediately before dissociation is owned by them solely as a transferee. And so those are some of the key things that happen as a result of dissociation. I just wanted to mention that. Of course, the point of this is you are out if you are the selling member here. And then the last part of the proposed 807 basically says that if there's multiple members doing this purchase, then the court's basically going to allocate who has to pay what and do what. And the court's going to attempt to preserve the existing distribution of voting rights and other designations, preferences, qualifications, so forth. Holders of classes of interests, just like, and I'll note that this kind of language about classes of interests and all of that is actually in the LLC Act. We haven't gotten there yet, but section 1001 sub 1 talks about one or more classes or series of interests in LLCs. And there's a comment on page 196 of ROLCA that refers to quote unquote holders of the same class or series of interests. You'll notice in our proposed 807, we didn't add the word series. That's not in the ORS corporate buyout statute. And since we haven't gotten that far yet on ROLCA to talk about whether we're going to have series LLCs or not.
I think that's probably a discussion for like 2 years from now. So.
Yes. Yeah. So if we adopt this, and whenever we get to the series LLCs, if we adopt series LLCs, we can add it in to here. But anyway, I just wanted you all to, in case anyone was thinking, gosh, that's weird, all these classes of interest and what have you.
We have classes now, but the whole series thing is a whole nother kettle of fish. So
yeah. So that's I think that's everything I had intended to do in presenting this potential proposal. And if anyone has questions, I'm happy to answer them, but otherwise I would happily turn it over to Aurelia to talk about her thoughts on this.
Yes, I'd like the hard sell.
Okay, I'll do my best. So just practically speaking, I think this is a very useful tool for resolving disputes in a way that is less expensive than more protracted litigation, and creates what a lot of people consider to be sort of a no-fault divorce provision for folks who are in a dispute. And I think we've talked about that concept a fair amount already. I also think that this preserves kind of a unique aspect of Oregon law. And there's case law that's starting to develop around ORS 9526. And so I don't think we should discount what the folks did when they decided to adopt this into the corporate statute, and preserve this in a context where I think it continues to make sense. I also think that there's an argument to be made that there should be some consistency between or amongst entities, at least when it comes to the default rules for the respective rights between members and the ways to resolve disputes between members. And I think that that sort of protects the carpet layers that we've been talking about, that they shouldn't have a remedy in one context but not the other simply because they decided to pick an LLC versus a corporation. That they should have the same remedies in both contexts. And the folks who are more sophisticated, who pick the LLC on purpose because they want to contract out of things, are going to be able to do that. But I don't think that our sort of unsophisticated folks should be penalized because they just happen to pick an LLC versus some other entity. With regard to this issue of discounts and some of that anxiety, you know, part of what the statute is designed to do is kind of balance competing interests. You know, the person who's bringing this suit is, you know, hopefully in good faith saying there's some problems here, I'm being oppressed, or there's illegal conduct or whatever. And this statute cuts off their ability, for the most part, to litigate those issues, and says, we're just gonna buy you out, that's it, you don't have a choice anymore. And so there's a balancing happening where we don't want to penalize that person for having brought the suit. And so we're not going to discount them for minority interests. We're not going to discount them for marketability. And that's, I think, what the statute is trying to do, is kind of balance those competing issues, not penalize this poor person for having brought, you know, what might be a legitimate suit, or hopefully is a legitimate suit. And so I think that's why there's no discount applied. And that's developed mostly through the common law. And the courts are really trying to look at what is an equitable remedy here, for allowing these people to, you know, go their separate ways, hopefully take, you know, take their economic energy, their, you know, just energy in general and their resources, and go do something more productive than litigate for the rest of their lives. So that's my general pitch.
So Aurelia, what are your thoughts about the valuation question, in the sense that, you know, they can take into account the cause of action when figuring out what the value, the appropriate buyout price is? Because my concern is that they're not going to save anything here, right? We're going to be fighting about the cause of action, not in the cause of actions context, but in terms of what is the appropriate buyout price.
Yeah, I mean, some of that is going to come in to the extent it actually affects the value. And a court's going to have to make a determination about how much should really come in and what actually affects the value versus this sort of petty side issues. But I think Cody's point is a good one in that you're not going to be doing that in front of a jury. It's just going to be a judge, and they can place restrictions on how much of that is really going to come in. And I've seen that some people try to address that ahead of time with, motions to sort of limit what issues are going to be tried. So I think there's ways to address that.
I think it is as a matter of how it works in practice. This provision that allows you to bring in your beef into the valuation of it, it still is a shorter, more expedited, more streamlined proceeding than a full-on litigation of the merits of your oppression claim. So I think it's still, like I said, before, that streamlined, cheaper, faster resolution is diminished somewhat because of this, but it's still a reduction in the length and cost of the dispute. And also, this doesn't happen. There are grounds for dissolution that don't raise issues that are affected by this as well.
I mean, have any of you, Cody, Kyle, or Aurelia, had a case under this provision in the corporate context? Well, I mean, how did it play out?
In what respect, I guess?
Well, where they were being bought out as opposed to going through the litigation. I mean, was it, because, I do appreciate your comment, Aurelia, that, you shouldn't be penalized. Because I'm thinking about the carpet layers here, right? Because our arguments are going to draft around this issue. But, our carpet layers are going to come in and they may not understand that this is a hallmark of the corporate context, and so then they end up in LLC land and they don't have this option. So I think that weighs for me more in favor of adoption, but I don't know how this is actually playing out in the real world.
Well, and one other thought is, I think that the carpet layers who we have sort of foremost in mind and thinking what is the default rule.
Yeah.
But there are a lot of not carpet layers who don't have a buyout provision in their LLC operating agreement. There are a lot of sophisticated businesses that are, I shouldn't say it that way necessarily, but there are some a lot of high dollar businesses and so forth that don't have forced buyout provisions in their operating agreements, for whether by choice or oversight or what have you. So it's not always just the carpet layers, who this applies to. And also just another thing regarding that, you mentioned that there's this assumption of the carpet layer that the typical corporate rule is going to apply in the LLC context. Well, in that regard, I've had cases where there are multiple companies, people with LLCs, they often have multiple companies, and where maybe the holding company, or I've had this case where the holding company was the Inc., and then there was two sub companies that were sort of the real estate co's that were the LLCs. Right. And then there was all were involved in the oppression claim. And it makes it extra complicated when you have these kinds of structures, which are not uncommon, to that, well, wait a minute, I can buy out these LLCs, but the LLCs I can't do a forced buyout under the statute of the LLCs, but I can for the company that owns the two LLCs 100%. This streamlines that kind of stuff, and basically it recognizes that people do a lot of funky things with having some LLCs here and some corporations there, and it treats them the same in that regard.
We like to call that tax planning, Cody.
Yes, tax planning. That's what I meant to say. Yes. But it makes it very awkward, because I've had that case and where you're, and also just people, even when there isn't that composite LLC and corporation structure, people often enough, they will apply the corporation rules to LLCs just by sort of dint of analogy, even though maybe the petitioning member if they had thought of it, or if they really didn't want it, they could make a good argument under current Oregon law. You can't force buy me out. This is an LLC, not a corporation. A lot of times people just apply these rules anyway right now. And also, I'll just note with regard to this fair value concept, if you bring that common law oppression claim or breach of fiduciary duty claim, et cetera, your damages are going to be measured by, fair value. They're not going to be measured by fair market value. So if you don't have the buyout, if you have this case get litigated on the merits and go to a jury trial, it will be a fair value question.
Jeff, you look like you have something to say.
Who, me?
Yeah, you.
Yeah, tangent here. If everybody would go back and look at B2. And again, it's just one more piece of heartburn that may explain away, but go through this whole process. The court decides the value. The transaction's going to occur, but then you can completely unwind the whole thing by dissolving the LLC. And really, majority is going to presumably be able to make that decision. They could be on the buy, sell, or the sell side. But it just seems odd to me that you go through this whole process and then you can unwind this whole thing, the majority, if they don't like the decision, the outcome of the purchase or sale, to dissolve the LLC. Just seems like an end run around the whole process and the decision.
Well, the action is a dissolution action, right?
Right. That's what the plaintiff is supposedly seeking. I mean, there are other remedies that the court could order, but that's how this comes about, is that the petitioner is seeking dissolution of the LLC.
But you get the result. You go through the whole case. One side exercises the process to sell or to sell their interest, I guess. You go through the whole process. You say you can't agree. The court has to determine the fair market or the fair value. I mean, you go through the whole process. A transaction is going to occur, but then the majority can, whichever side they're on, buy or sell, the majority can just end it by making a decision to dissolve the LLC. It just, I don't know. It gives one party, the party with the majority interest, control to do an end run around the decision once you go through the whole process. Just seems odd.
I think it accomplishes the purpose of the statute, though, which is to stop the fight and stop the litigation and bring the thing to an end one way or another. So if you're thinking about the goal here is not to have an interminable fight in circuit court through the appellate courts up the Oregon Supreme Court, because honestly, these kinds of fights could get really, really nasty, and they do that. It does accomplish the purpose of giving these people a divorce, sending them on their separate ways. And so, yeah, it's kind of weird in the sense that it gives the majority the chance to throw in the towel, but it also accomplishes the purpose.
I agree, but the flip side is just to take that piece there. So a minority is selling to majority. Majority doesn't like the purchase price that the court came up with. So majority just dissolves. It gives a lot of, as you said, throwing in the towel. It gives the majority, though, to throw in the towel after you go through the whole process. And I just wonder, I can see circumstances where there's a fairness issue to that, because, there's a resolution, minority selling to majority. Majority doesn't like the purchase price or the payment terms. So you know what? I'm just going to liquidate. And then I'm just going to reform the business under a new LLC. There's a potential unfairness factor, I'm just saying, in that scenario.
Yeah, I think Jeff, the problem, though, is when you're looking at these kinds of fights, and I see these kinds of fights by the time they end up in bankruptcy court, because they do, or in receiverships. And the reality is, by the time that this thing is so broken, there are no good alternatives, right? It's either interminable litigation or you break the thing apart in the best way you can, but it ain't going to be perfect. Nobody's going to like the result, but it maybe is better than fighting for the next 10 years. And so I actually really like the idea of having this default rule and this way of giving people an off-ramp. I'm perfectly fine with the idea that those who want to and have good counsel, like we have on this call, will draft around it and do something different, because it forces them to think in advance of what they want and then do that. But I do think that there are a lot of these cases, and I don't think the carpet layers are a particularly good example for this one, because that's primarily a services business. It doesn't have any assets. You know, your customer list is only as good as your customer list. And honestly, the guy who's doing the work is the one who probably has the benefit of that. But it really comes up, I think, in situations where people get together to buy a rental house or a little strip mall, or, you know, something where that's got, you know, kind of a hard asset, a piece of real estate, probably less likely to be used with something like a patent, but where you have some kind of tangible thing that's got value. And finding a way to get those people a divorce when they haven't thought about it ahead of time is, I think, a hugely good idea, because what you see is these people just burn up all the value fighting with each other. And the asset just dive bombs into the ground and gets ignored because they can't agree to do anything like pay the mortgage, or, you know, and then it gets foreclosed, or they can't figure out how to pay the maintenance, and then they get all the damage when the roof leaks and it's got water damage. And so it just seems to me giving people a faster option to just get it over with makes a ton of sense.
And I
would also
go ahead, James. I know you're trying to.
Sorry, I was just going to toss in, Jeff, on your concern when the majority says, "Oh, we don't like the price the judge gave us, we're going to just dissolve." The next step is they do in fact dissolve, and everybody gets what is in fact the fair value. I mean, in retrospect, that will be the fair value. So I don't feel like there's a risk of them gaming it, because it's either the court got it right or wrong, but the proof is in the pudding. When they dissolve, they're going to get the true value, and they're going to split it up according to their percentages.
Well, capital accounts.
Jeff, you're on mute. Jeff's on mute. He's trying to.
Oh, I'm sorry. I was on mute. I don't know how I didn't do that. No, I was just saying, James, I'm not sure I wholly agree in all circumstances on the basis of going concern value. You know, if you have a business, particularly a service-oriented business, and it might be the plumbers who have built a business up to 15 trucks and 25 plumbers. So it could be a pretty significant business, even though it's a plumbing business is our example. I'm just saying that when you dissolve a business, in theory, you lose the going concern value, because everybody goes their separate ways. Who gets the name? Who gets the trucks? Who gets the client? I'm not sure that it is of equal value if you know, somebody agrees or there's a pay for a 20% interest on a going concern business versus liquidating it, because all you're doing at that point is selling the trucks and the tools and distributing the net after you pay the creditors. So I'm not sure it is the same result.
I wonder though, Jeff, your point, what do you think of Teresa's point that by the time you get to those things, they're pretty irrevocably broken anyhow, usually?
I agree. And I agree with Teresa's point that, you know, it's just, you know, avoiding the efficiency of it, avoiding 10 years more of litigation to see where it comes out. I mean, those are valid points, but I'm just saying there's points on both sides of the equation here. Yeah, and again, I'm reacting to what is potentially a fundamental unfairness that the majority could bestow on the minority on either side, whether they're buying or selling, by just simply saying, okay, I don't like the results, so I'm just going to cause a liquidation.
Susan has appeared, so I think she must have something to say.
Hi, thanks, Valerie. Yes, and I try not to weigh in on the details because you guys are the certified smart people, and I'm just the person who watches the legislative process. My 2 cents worth on this is, and I can't remember the session or the specific bill, but this was a hard-fought change a couple of years ago, and it's existing Oregon law. And one of the roles that this committee or work group plays is to look at the provisions of RILCA, the revised RILCA, and look at existing Oregon law and see where you need to pick those up and mesh those. And I think it's really important to note that if you make a substantial change to something that was over a couple of years ago, people are going to come back and they're going to take issue not only with that provision or lack of that provision in this omnibus bill, but then they're going to start picking apart other pieces. So I strongly encourage this group to consider looking at going some kind of route that would be closer in line with the work product that the subgroup came up with, because it does bring in existing Oregon law and makes it mesh with your revised.
Susan, the existing Oregon law, though, is in the corporate context. It's not in the LLC context. And so didn't the legislators have the opportunity at the time that this was brought into the corporate code to also bring it into the LLC code?
They did, but the fact that they didn't do it at the time, I think, is just a matter of them focusing on one small piece. This group, I understand, is trying to look at the big picture and all the spokes, and you're thinking about moving forward with other projects. And so I would just encourage you to think big picture, that if you're going to try and make this one of a couple of a series of corporate code updates, LLC updates, LLP updates, whatever, I might be using the wrong terminology, but my point is simply that this is one thing that those parties who were involved previously, and they're still wandering the building, just letting you know, even if we're doing it virtually, those people are still present and they will be aware. And I'm just, for what it's worth category, I really think it's worth noting.
Well, and I think that goes to Aurelia's point of parity within the entity types.
Can I ask just a question? Does anybody have any insight why the drafters of both uniform acts did not put this in ROLCA? Is there any insight on that?
I looked around. I didn't find anything on that. So I don't know why.
Well, is it part of the Model Business Corporation Act? I think it's an Oregon specific.
It's been part of the model. Okay. It's been part of the Model Business Corporation Act since the 80s, but it has never been part of the Uniform LLC Act. And when Oregon did its statute on this, the 6952, that statute doesn't only talk about forced buyout. That's part of it. But it also talks about how the corporation, rather than being dissolved, the court can order all these other lesser remedies for the problem. And they list all these different things, many of which were basically taken from Oregon case law going back many decades, to the 50s and before that. There was this case, Baker, the Oregon Supreme Court decided in the 1970s, where they specifically held, hey, just because dissolution is sought doesn't mean dissolution must be ordered. You can do lesser remedies, and the cites and talks about a whole bunch of lesser remedies. And the LLC Act, in its discussion of dissolution and so forth, it specifically has a section, I think it's 701B, that talks about, oh, you don't have to do dissolution, you can do a lesser remedy. And they put that in there because a lot of states had, for whatever reason, decided that if the statute talked about dissolution, that was the only remedy that the court could order. And so this ORS that we have in the corporate context here from 2001, it talks about those issues as well as this buyout. And the corporate statute was really, the NATO bill. Steve Nato was a major proponent of the bill and talked about it. There were other stakeholders as well. And so that question of why they didn't make it apply to LLCs, I think in 2001, LLCs were not as common as they are now. We only have an LLC Act since 1993. Right. I think businesses at issue in the NATO litigation were corporations. And so, in short, I don't know that there was a reasoned decision after vigorous discussion to apply it to the LLC context.
I would add that the most common court-ordered remedy is often a share purchase. And that developed through the case law. And so having a process for it by statute, I think makes a lot of sense.
Mm-hmm. Mm-hmm. I think, does anybody else want to weigh in, or should we do a vote on this?
Well, I just want to suggest, because you're going to do the vote, that my feeling is, just so people understand, is I think I'm going to vote yes because you have opt-out provisions.
Yeah.
So we have a choice as drafters. So I'm going to be yes because of the opt-out.
Okay. So Jeff is saying that we should vote.
Well, I feel like if there was no opt-out provision, I might end this, but because I might be with Mohsen on, but because there's an opt-out provision, you have a choice. And so the flexibility is what makes it workable for me.
Okay, David, you look like you want to say something.
I'm just going to say, I thought Teresa's arguments were quite compelling. And in my own personal experience, when people come in to talk to you and there's a dispute among members, is that there generally is, and they have a terrible operating agreement. There just is no easy remedy. And all I tell them is the winner in this is going to be me in terms of the attorney's fees you're going to pay. So this sort of intrigues me in the sense, and I think James makes a good point. We can just opt out if we want to do that, but it'd be I would favor it as a fallback or a default provision.
Okay, anybody else want to weigh in before we vote? All right, so all in favor of, with a couple of edits that we talked about over the course of this, incorporating this into new section 807 of our proposed draft, raise your hand.
Are there any
people who are not pictured? Willie, Susan, Catherine, phone number ending in 7187.
And we know about Mosin.
Yeah, okay, I was gonna make, well, Mosin wanted to be known about.
I don't get a vote, but.
Oh, that's true.
No,
Willie,
Susan,
do you have
thank
any
for your
thoughts?
I don't have any thoughts. I did want just one quick clarification, just very minor one. We can go back to section 8.2, I think it is. And in the middle, it mentions the notice also must advise the recipients of their right to join in the election to purchase shares. Is that something you mentioned? That would be, is shares going to be the word we would use, or would it be interest?
All the interest.
That's a good catch. That's my error. Again, that should be the entire interest.
Thank you, Willie.
Thank you. That's
well.
Kathy, do you have anything you want to say? No? Okay. And then phone number ending in 7187.
Yeah.
I think that's our other Department of Revenue person. Okay, well, so hearing no other comments, so all in favor, we raised our hands and it was pretty unanimous.
Yeah,
I
think everyone but Mosin.
Yeah, and then any opposed, Mosin?
And I have that for the record, and I know he's opposed.
Yes, it sounds like he was very emphatic about that.
He was friendly but emphatic.
Yeah, no, that's fine.
Well, he's been very consistent about why he is. Oh, the phone number is chimed in.
Hello, this is Victoria Johnson, Oregon Department of Revenue. I couldn't get myself off mute. 7187. No objections.
Okay.
Thank you.
Thank you, Victoria.
And
sure. Thank you.
I have to drop off right now for another meeting. I wanted to let you know. All right.
I appreciate your participation. Thank you.
All right, thanks. Bye-bye.
I think it's fine to disagree. I mean, it's like we've certainly had non-unanimous votes before. So, but.
Well, at the call, we may have convinced him to swing over to the other side.
Well, that's when he doesn't show up. He doesn't get to join the
he teaches on Wednesdays this term. So, but we'll discuss that in scheduling the next meeting.
All right. Okay. So Cody, will you please make those edits to it and recirculate to the group, or give it to Sandy to recirculate to the group?
Cody, just send those back to me, and then I'll put that in our notes, and then send it back out to the group. Thanks, Cody.
Yeah, you bet. And then one other question I had on Article 8 was there were, I think, 2 or 3 issues, I think 3 issues that various people were going to talk to Defense Bar about and find out what their views were about like expert fees and ability to vary certain aspects of Article 8 via Section 105C, and also the definition of what is a direct versus derivative claim. Is what my memory is about the 3 issues the Defense Bar was going to be sounded out about. And I, maybe we take our break now or not and discuss those issues. But I just was curious whether that had been done, and if so,
Yeah, I think we're missing a few people too. So I know I haven't done anything in that area. But who assigned to do that? Do you have that? James, did you talk to people?
I did that. I have a vague memory that maybe Cliff also volunteered. Yeah. So maybe we should wait. I don't know.
Yeah, why don't
Cliff called out late for this meeting today. He had something that came up at the last minute.
Let's table that for the next one, but I'm making a note I'm trying to be better about writing stuff down. And Sandy, can we talk after this about sort of those follow-up items?
Sure.
Okay.
I might have to schedule another time with you. I have another
Yeah,
meeting
no,
right
that's
after this,
fine.
but we can schedule later in the week.
Okay. So let's take a 10-minute break. It's 10:30. Let's come back at.
And I'll apologize in advance for any coughs or nose blowing. We've had the crud going through the house. Lots of kids home the past week and a half. So it's a wonder I'm prepared at all. So Article 9 is foreign LLCs, which we all know means entities from other states or potentially from other countries. Section 901 is governing law. This is the internal affairs doctrine is going to come up. And just to situate you, we're talking about the 700s in chapter 63. And specifically for this first section, we're looking at 63.714. So looking at 901, Clause A says, the law of the jurisdiction of formation of the foreign LLC governs the internal affairs of the company, the liability of a member as member and a manager as manager for a debt, obligation, or other liability of the company, and the liability of a series of the company. So pausing on that last one, I have never seen one in the wild. I don't know how many of you have. Series LLCs exist in, I think, 15 states. The idea is that one set of filings allows you to form multiple entities. So you sort of file a template document, and then it applies to multiple entities that you form basically on paper without filings with the state after that. We've obviously never had that in Oregon, and I think this is fine here because it's just protecting, if another state has that concept, we're just allowing that to exist and not saying it can't exist here, which I think is fine, and that's what would happen here today anyway. Turning to 63.714, Clause 1, you'll see talks about the laws of the state or other jurisdiction where the foreign LLC is organized, governs its organization and internal affairs, and the liability of its members. So a few minor differences I'll call out. ORS references organization as well as internal affairs. I think that's probably a subset, so I'm not concerned about that. Current Oregon law only talks about liability of members, whereas ROLCA says liability of a member as a member and liability of a manager as a member, and then adds the clarifier for a debt, obligation, or other liability of the company. So I think those are all improvements and consistent with Oregon law, but it makes things that are currently implied express. So I am all in favor of 901A, and I'll pause there before I jump into B. Okay, 901B, a foreign LLC is not precluded from registering to do business in this state because of any difference between the laws of its jurisdiction and the law of this state. So just because Delaware law is different doesn't mean that entity can't register here. 714, chapter 63, 714, sub 2. This is a really strangely worded paragraph, in my opinion. It says, except as provided in subsection 3, a foreign LLC may not be denied registration by reason of any difference between the laws of this state and the laws of the state where it was organized. And that lead in, except as provided in subsection 3, implies to me that under subsection 3, you're going to find out that the Secretary of State can in fact deny registration if there were a difference in state law. But that's not what subsection 3 does. It basically just says, no foreign LLC shall be authorized or permitted to exercise any powers or purposes or conduct any business or affairs in this state that a domestic LLC is prescribed from doing. So really, it's just saying, if Delaware law says that every LLC can be a bank, as an example, that doesn't import into Oregon. You can't be a bank just because you're a foreign LLC. So I think that's all it's really trying to accomplish, but it's phrased funny, and it comes up a couple times later that I'll come back to. So I thought I'd focus on that for a little bit. But turning back to ROLCA, 901B more or less tracks 714 sub 2. And then 901C says registration of a foreign LLC to do business in this state does not authorize the foreign company to engage in any activities and affairs or exercise any power that an LLC may not engage in or exercise in this state. So same concept that we find in 3. I think the gist and the substance, the intended substance of all of these are consistent with current Oregon law. It's just written better in ROLCA, in my view. So that is the entirety of 901, and I'm recommending that we adopt it as is.
I agree.
We're cooking. 902. Registration to do business in this state. So 902A, a foreign LLC may not do business in this state until it registers with the Secretary of State. We are now looking at 63.701 and specifically sub 1. A foreign LLC may not transact business in this state until it has been authorized to do so by the Secretary of State. So a little bit of nomenclature differences, doing business versus transacting business, registering versus authorized by. I don't see any meaningful distinction. So that's all I really have to say on 902A. 902B says a foreign LLC doing business in this state may not maintain an action or proceeding in this state unless it is registered. This is paralleled in 63.704 sub 1. A foreign LLC transacting business in the state without authorization from the Secretary of State may not maintain a proceeding in any court until it obtains authorization from the Secretary of State. So basically the same concept here. While we're in the ORS, there's a couple of provisions that follow that are not, there are no analogs in ROLCA. So 63.704.2, the successor to a foreign LLC that transacted business in this state without authority and the assignee of a cause of action arising out of that business may not maintain a proceeding based on that cause in any court in this state until the foreign LLC or its successor registers. And then 3, a court can stay a proceeding commenced by a foreign LLC or its successor until it determines whether the foreign LLC or its successor requires authorization from the Secretary of State. And if it so determines, the court may further delay the proceeding until the foreign LLC obtains authorization. So I think this is just a little more background and a little more context. I think this is probably implicit in the court's inherent power, but I'm interested in what others think. I know Teresa had a good argument last month about liking the ability to point to a specific site when you're trying to get a judge to do something and not arguing from the implicit powers. So,
right. And I would point out too that, so is there a corollary to, or an analog to 63701 sub 2 in ROLCA too, which are this does not constitute doing business?
We'll get there. We'll get there, yes.
Oh, okay. Because
it's organized differently.
Okay. I mean, I would generally be in favor of being more inclusive than less inclusive when we already have language in the ORSs that we can pull in. Teresa, do you have a thought about that? You look like you want to say something.
I think James identified exactly what I wanted to say and said it for me. So yes, I do think that we should add 704.2 and 3 here. It would be very useful.
It is, I suppose, in some circumstances helpful to guide a court to stay a proceeding rather than dismiss it and let it be filed again for statute of limitation purposes. So I don't see any reason not to add these provisions other than, the general concept of trying to stick with ROLCA. So I'm fine adding 2 and 3 from 63.704 if other folks are.
Do we need to talk about 4, 5, and 6 too?
We will, yes.
Yeah, I'm fine
Yeah,
with that. I think that makes a lot of sense.
For what it's worth, the 700s are it's substantively very similar to Rolka, but the provisions are just all jumbled up. They're not going to track, but I've got notes to make sure we pick everything up.
Okay, good. Yeah, because I agree. I think if we've got it in, I think 2 and 3, we should just incorporate under B.
Okay. Similarly, sub 4, since you just asked, Valerie, sub 4 basically says that a foreign LLC doing business in this state is liable to the state for the years or parts thereof during which it transacted business without authority. Basically, pay your overdue filing fees.
Right.
Which I don't think I saw anywhere in Rolka. It's not in the foreign LLC section. I don't know if it could be somewhere else, but I think this is worth adding just on the assumption that the Secretary of State wants to be able to continue charging for those missed years.
That makes sense.
I wonder if the Secretary actually has charged. I mean, how do you know that? How do you enforce that?
Well, I think it comes up when people try to file a lawsuit and they can't do it and they have to go back and register their LLC, and the Secretary of State says, yeah, we'll let you register your LLC, but you're going to go back and pick up all the past years. And I think they do. And because I think we are trying to be as revenue neutral as possible, I think it's really important to pick up this provision that we have. Because if they've been getting $3 from this, we don't want to have a fight in the legislature about how they're not going to get that $3 now.
It's more than $3, but yes, I agree.
I'm sure it is, but I'm saying even if it's only $3, it's not worth fighting over. And if it's more than that, all the more reason to keep it.
I do want to make a point, though. I actually dealt with this probably about 4 or 5 years ago, and all we did needed to file the lawsuit for an entity in the state and wasn't qualified. I said, well, you can't bring the lawsuit under the statute. So all we did is file the qualification as if we were just starting to do business in the state. The Secretary of State accepted it, and we filed the lawsuit. That's, I mean, on a practical reality, you're just filing a registration. The Secretary of State doesn't know, nor is it going to ask, when did you start doing business in the state? They just accept the registration. You're qualified. You can file the lawsuit. So anyway.
Your opposing counsel might bring it up if they're trying to be a pain.
Okay, they did in the, you know, because I always have the question, and you know, as a tax lawyer, I get asked, should I qualify to do business in the state or not? And one negative is you show up, as I like to put it, you show up in the radar screen. You know, now the Oregon Department of Revenue knows about you. You better be filing your tax returns. And sometimes, you know, Nexus tests and whatever, and this is more historical because Nexus has gotten a lot tighter in recent years. But, you know,
the definition has blown up like a water balloon.
Yes, yes. So, but my point being is whenever I'm asked this question, I kind of balance, you know, I want to find out how much business, what you're doing in the state, and is it really necessary? Because notwithstanding the statute, really, if you don't qualify and you're doing business in the state, the only downside I've ever seen is you can't bring the lawsuit. And if you need to bring a lawsuit, fine, then just qualify as the example I just gave. You just file the qualification, you know, eliminate the problem and file the lawsuit. So, so I'm always, when I ask this question, should I qualify to do, you know, business in the state? One thing I'm thinking about is, do you want to show up on the ODR's radar screen? And, you know, do you really have enough of a connection where you should do it or not? So I'm always looking to try to avoid it under certain circumstances. And the only downside I've ever seen was you can't file a lawsuit. Anyway.
So I agree with Jeff entirely. And that's kind of what I've always advised, but we did some research for a client, and Oregon tends to be a more favorable statute than a lot of other states. Some states have more consequences for failing to register. So, which was an eye opener for me to some degree.
Well, then that raises put more teeth into this thing. I don't know, probably not, because I like to balance that argument. And there's a few occasions where I've said, no, don't qualify to do business in the state. Don't show up on the tax radar screen. And there's really no downside, depending on what they're doing, of course, other than if you need to file the lawsuit, and that's able to fix it. You're able to fix it by just filing the qualification and then go file the lawsuit. So it's an interesting statute when I read it, because I don't know if we've ever really enforced that, or how we enforce that, to go back multiple years and say, well, you've been doing business in the state for 10 years, so pay us for 10 years of qualification.
Regardless, I think we probably should keep it.
Oh, I agree.
For policy, because it's in statute already, I would agree too. We probably need to put it in there into our version of ROLCA, because for policy reasons, it's there. We don't want to get pushback because we don't put it in there.
Yeah,
Practically, I don't think it's ever really amounted to much for the state. That's what I would guess.
I think that's probably true. For what it's worth, Jeff, I don't know how big a swath of factual circumstances this covers, but it is possible to file a lawsuit without registering. The test really is, are you doing business in the state? So in theory, if all you were doing, for example, was foreclosing a security interest, say a lender on a real estate mortgage, they wouldn't necessarily have to register. And to your point, most often you're just going to advise them to do it so that you avoid that argument out of the gate in your lawsuit. But well, I just wanted to mention that.
Yeah, and the interesting thing, circumstance is you have to have a pretty smart lawyer on the other side to know the statute that you need to qualify to file the lawsuit, and to determine that there wasn't a qualification and bring that up as a defense, really probably a motion to dismiss the lawsuit. But then you do a motion to dismiss. It's funny, just to take it through, you could do the motion to dismiss, then what happens, the case gets dismissed, the LLC qualifies to do business and refiles the case.
I'll take the compliment, Jeff. I made that argument once when I was a litigator, and actually before it got dismissed, they just registered 2 days after I filed my motion. And by the time we got to the hearing, the court's like, why isn't this moot? Yeah, thanks, Judge, it is.
All right, so we'll incorporate that section in.
Yes. So now I'm up to section 902C of ROLCA. The failure of a foreign LLC to register in this state does not impair the validity of a contract or act of the company, or preclude it from defending an action or proceeding in this state. And for this, we're looking at sub 5 of 63.704, right next to where we just were. And here it says, notwithstanding subsections 1 and 2, the failure of a foreign LLC to obtain authority to transact business does not impair the validity of its acts or prevent it from defending any proceeding. So ROLCA slightly improved by referencing contracts as well as other acts, and also, I guess, action in addition to proceeding. Pretty minor differences, but generally speaking, I'm in favor of ROLCA there as well. 902D, a limitation on the liability of a member or manager of a foreign LLC is not waived solely because the company does business in the state without registering. We're now in sub 6 of that same ORS. Member of a foreign LLC is not liable for the debts and obligations of the foreign LLC solely by reason of having transacted business in the state without authority. ROLCA is an improvement by specifically mentioning managers, otherwise substantively the same. ROLCA 902E is new, and it says that 901 A and B, so this is internal affairs type stuff, that applies even if a foreign LLC fails to register under this article, which I think is probably what everyone expects today. So in total, I'm in favor of 902 in its entirety as is.
With the addition of the language from
704.
Yes, thank you. From subs 2, 3, and 4.
Yeah, I agree. Anyone opposed? All right, moving on.
Nope.
Section 903, foreign registration statement. So we have application for authority today. Nomenclature is different. I don't think it's different in process or substance. You either qualify or you don't. To register to do business in this state, foreign LLC must deliver a foreign registration statement to the secretary for filing. The statement must state, 1, the name of the company, and if the name does not comply with the naming conventions, so for example, including LLC in your entity name, an alternate name adopted pursuant to 906A, 2, that the company is a foreign LLC, sort of obvious. 3, the company's jurisdiction of formation. 4, the street and mailing address of the principal office. And if the law of the company's jurisdiction of formation requires the company to maintain an office in that jurisdiction, the street and mailing addresses of the required office. And 5, the name and street and mailing address of the company's registered agent in this state. So for 903, we are looking at ORS 63.707. So A, foreign LLC may apply for authority to transact business in the state by delivering an application to the secretary. The application must set forth A, the name of the foreign LLC, or if the name of the foreign LLC uses is unavailable, another name that satisfies 63.717. So that's pretty much the same as section 903.1. There's no analog to 903.2, the concept that you have to state that your company is a foreign LLC. I'm fine sticking with ROLCA. It seems obvious that's what's going on, but doesn't harm anything to include it. Going back to 707B, the name and state or name of the state or country under whose law the foreign LLC is organized. So that's the same as sub 3 of section 903. C in the ORS is different, I should say. The foreign LLC's registry number in the state or country under whose laws the foreign LLC is organized. So, you know, if you're registering a Delaware LLC, you have to list your Delaware registry number. I would be interested. I don't know if we have, I think we don't have someone from Secretary of State's office on anymore, but I don't see this as particularly helpful to have the registry number. Once you know the state, you go look in that state on their website. So this to me seems to be a little bit of extra work that doesn't really add value for anybody, but maybe Secretary of State's office.
Can I comment on that too? Because I think it does add value.
Oh, I was going to disagree. Go ahead, Teresa.
Yeah, so oftentimes when you're trying to trace money through LLCs, when people are of the type to want to form lots of them in lots of places to hide it, it can be really useful to actually connect entities that are the same versus ones that are similarly named. And so I actually think it's super helpful to have the registry number from a user point of view. I don't know if it's useful to the Secretary of State, but it's useful to me.
And I was going to say the same thing in terms of names. Sometimes names can be very confusingly similar. Plus, also there's name changes, and the Secretary is tracking name change, you know, from the current name to the old name. I just think that it's better to have the registry number because it's just much more succinct to find that entity and know exactly which entity you're dealing with. You know, all the time I'll have like families that will do multiple names that will have XYZ1, XYZ2, XYZ3 and stuff. So I would suggest including the number because it's just another way to identify, and a more succinct way to identify the entity you're dealing with.
I agree. And it's not that difficult, right? So
I was just going to add on this particular part that registry number language was added in 2011 to our Oregon statute. So I assume it's falling under that rubric of, you know, things the legislature has decided in recent years are things we probably don't want to muck with.
yeah. Susan will reappear and tell us that we need to include it if we don't.
Policy reasons.
Okay, so it sounds like we want to add
Yeah.
C from 63.707. D is also new, or different, I should say, again. The foreign LLC's date of organization, and either the date on which the period of its duration expires, or a statement that its duration is perpetual. There's no analog in ROLCA, and I'm guessing that's simply because ROLCA is going away from the concept of term lengths for LLCs. So I'm comfortable with that, but welcome any input.
I think all of these things that are, I mean, because the list in 707 is much more comprehensive than the ROLCA list, right? I mean, I think my recommendation would be that we just adopt wholesale all of this additional information that that we currently have in 707, because it reflects this move towards greater disclosure that the legislature did a couple of sessions ago.
I'm not disagreeing with you, Valerie, but I'm saying that information in D is easy to look up once you can, because every Secretary of State website, I think, provides that, at least the formation date. But I'm not disagreeing with you. From a policy standpoint, we just put everything in the ORS into ROLCA just because it's already in the ORS.
Yeah, I mean, there's some stuff where it's worded weirdly in like that one section that you mentioned, James, where our language is a little bit weird. That I think we can go with the ROLCA language, it's better. But I think where it reflects a clear policy decision on the part of the legislature, I think we probably need to include it.
Can I just throw in a contrary view on this?
Of course, Cody.
Sorry. Well, I mean, I think we should adopt C because that's this policy choice of the Oregon legislature. But I think James had a good point as to D. I think D is focused on this issue of the term limited LLC, which if we've already discussed that for in-state LLCs, and we're not going to be requiring that for in-state LLCs anymore because we're moving away from ROLCA. And this D, I don't think that was added in 2011. And I think if we're moving away from requiring this statement of are you perpetual or term limited for local LLCs, I don't know that I think that removes the policy reason for requiring it of the foreign ones as well. And then just to make the point further, if you look at H, 707H says you need to have a statement of whether the foreign LLC is member managed or manager managed. Now, I mean, maybe if everybody adopts ROLCA, like we aren't doing that for local.
No, I understand, but I mean, this may fall under the idea that we may have certain provisions that are phase-in, right? Where you're going to have entities, because it would be awful if you had a foreign LLC, and this has happened before, sort of in the reverse, where we've had a term limited LLC that someone treats as being a perpetual LLC because they don't understand that, it can end. So, I think we're giving them the benefit of the doubt on their how they handle stuff based on how they're organized in their home jurisdiction. If their home jurisdiction still requires terms, and I think we need to include that information.
Yeah, well, I'm not against. I just wanted to say that there may be a policy reason that we are a choice we're making in ROLCA for local LLCs that might call for not adopting D and H, but I don't care whether we adopt it or not.
Well, I think it's a matter of, we could include in the comments that if all states move away from term limited LLCs, we can get rid of this section. But I think it's as a matter of disclosure to people transacting business with the LLCs, it makes sense to keep it.
I think that's a good point. And I would add to it, Valerie, is that while on virtually every Secretary of State website, you can find the date of formation, virtually none or probably none of them will tell you whether it's term limited and when the term expires. In fact, the only way you can find that typically is you have to order a copy of the Articles of Organization or Certificate of Formation. And even then, some states may not require it and may only require it in the operating agreement. So it is information that you're gonna, in terms of term limit and the expiration date, the only way you're going to get that is to require it. And you make a good point. People doing business with the LLC in the state have a right to know whether this is an LLC and limited liability or it expired, it dissolved, and you're not dealing with a business entity anymore.
Sorry.
So I don't feel strongly either, but I lean toward Cody's position that we ought to treat them the same. There are some, I think there's a little more nuance than just adopting ORS wholesale. There's at least one instance where where ROLCA has more and in a way that I think is helpful. Okay. So if we're registering a Delaware LLC in Oregon, we have to list the Delaware registered agent, which I think is helpful for all the crooks that Teresa's chasing, right? She wants their information, more addresses is better. So I think that's a positive addition. And certainly there is one clause in 707 that I don't want to adopt, which is G, and that is the statement that the foreign LLC satisfies the requirements of 63.714.3, and that's that weird provision I pointed you to before, where you basically, I actually never noticed this. I pulled the foreign LLC registration form from the Secretary of State's office. I can't tell you how many of these I've coordinated filing. I have never paid attention to the fact that there is a statement, not something you fill out, it's just written there, the foreign LLC satisfies the requirements of ORS 63-714 sub 3. So you're basically representing to the state of Oregon that there isn't any weird provision in your local state law that is going to conflict with what happens in Oregon. And that doesn't make sense to me anyway, because to me, it's just, you can't exercise those rights in Oregon, right? That's that distinction I was calling out before. So at a minimum, I would say we get rid of G.
That sounds reasonable. And I do think that,
I don't know. I mean, I guess on that one, I don't know. That seems like, I'd be very curious what the Secretary of State says about that one, because currently they're having, when they file to be in Oregon, they're certifying that they're not doing anything Oregon doesn't allow them to do. That seems to me like a helpful thing. I don't think they're talking about what foreign law says. They're just saying that they're not coming here to do anything they're not allowed to do here.
I think you're giving more substance to what's actually written. I think it's written in such a clumsy way that it's hard to know what you're actually representing in that clause.
Well, I think we should get the Secretary of State's folks input on that, because if they mean something more like what Cody is saying, then I tend to agree with them. If it is more like what you think, that the limited writing, then I would be more inclined to agree with you. But I'm curious as to what the Secretary of State thinks, because if they mean something more than that, then let's write it to be something more than that.
Yep.
Yeah, I mean, I read 714 sort of 2 and 3 to basically be saying, we can't, we're going to let you register here regardless of what your foreign law says, but letting you register here isn't going to give you greater rights to do business here than we let our local companies do.
And I think that's a fair statement of the law, and that's what it should say. I don't see what value is added by having somebody make a representation about, again, I'm not sure what they're representing, but to me, the law says what you can do, and that's it. That's sort of the end of the inquiry from my perspective.
Mm-hmm.
But we can, I think Teresa's point is good. I think we should ask for Secretary of State's input on that. So going back to 707, E is the address of the principal office, your registered agent basically here.
James, can I?
Your principal office here. Yeah, Jeff.
You mentioned earlier that ROLCA requires you to give the registered agent for the state of formation. So when I look at subsection 4, 903.4, the language it says is, if the law of the company's jurisdiction or formation requires the company to maintain an office in that jurisdiction, is that the registered agent? I mean,
look at 5. Look at 5. Look at 5.
Just registered in this state. That's the agent in Oregon. So, and I like what James said, and I agree. I like the fact that it requires the registered agent in the state of formation, the foreign state. But it just, the language says an office the states requires the company to maintain an office, and I mean, and that could be a principal office. I mean, it doesn't say registered agent. I would like it to say an office or registered agent or something, just to be clear that you have to tell us you're registered agent in your foreign state.
I know some states' laws talk about a registered office and an agent at that office. So it's a good question, Jeff. I don't know if this is definitively intended to pick up the registered agent in the foreign jurisdiction. That's how I read it, but I agree it could be read in more than one way.
Yeah, and there's no comments, it looks like, on it, but can we say maintain an office or registered agent or I don't know. I mean,
so Jeff, are you saying, so we would change 4 to say the street and mailing addresses of the company's principal office, comma, registered agent?
No. Read on, and comma, here's my problem. If the law of the jurisdiction or formation requires the company to maintain an office, it's that word, an office. It doesn't say a registered agent, which is what we really want. If they're required, principal office.
So would you add maintain a registered agent or office in that jurisdiction?
Yeah, I don't know what office is intended. I just wanted, I'm concerned that office can be argued that it's not the registered agent. And what I really think we should have is the registered agent in the foreign jurisdiction.
Teresa, you have any thoughts on this?
Isn't this really a question of what other jurisdictions are requiring? Because if they're requiring offices as opposed to requiring registered agents, then I think that's what the information they're after. If the other states are requiring registered agents, then I agree with Jeff. They ought to be telling us they're registered agent. But I think that these provisions are from states that are saying, if you want to register to do business here, you have to have a physical location in our state. Doesn't necessarily mean it's your registered agent, because your registered agent can be somebody else. But we expect you, in order to do business in state X, to have an office somewhere in state X. And what happens, I think, in those states is that usually, you know, there's these little services that provide, you know, everybody has their office at 123 Main Street. And there's like 700 companies who have their offices at 123 Main Street, because it's just a little hole in the wall that serves as an office for places.
Or a trillion.
I think there are places like that in parts of the world.
But isn't in terms of the states, I'm not aware of any state that doesn't require a registered agent. And the value of this information is if you want to file a lawsuit, you know, and particularly if you want to, if for whatever reason you want to go to the jurisdiction of formation and not in Oregon, then you know who to serve in that jurisdiction. You could look that up anyways from the Secretary of State.
I agree with you for the United States, but I think we're talking about foreign as in real foreign, like
for both. It's both. I think foreign means outside.
Foreign means both.
Anywhere.
Yes.
And I think I want to say that there's, I don't remember where it's at, if it's like the Turks and Caicos or if it's Belize or it's one of these, it's some of these places where they have, where people hide their money, right? And it's a cottage industry for those places to require businesses who want to hide out in their jurisdiction to maintain an office there, because that's how they're collecting revenue from their cottage industry of hiding money. And they require that. And that's how they all end up at 123 Main Street. And I don't mean to put a slur on any particular jurisdiction, but it seems that I have seen this before. So and I can't remember where, but you have to have an office, and it ends up being this crazy kind of
scam. Piggyback the IRS's approach to this, because they now require a partnership representative or designated individual in the United States. You know,
what I was going to suggest that I think may resolve Jeff's concern and also be responsive to what James was saying is, you notice how 4 has this and if clause. What if we just add an and if clause to 5? And then, you know, if the foreign state, if it's Delaware or Panama or wherever, if they require both a real office and a registered agent, you'd have to provide both of those addresses to Oregon. If they only require one, you would supply the one that foreign jurisdiction requires.
And I like that, because I was going to say that what happens if the state, in this particular case, the foreign state requires an office and a registered agent, then in order to comply with 4, you just give the office address. You don't give the registered agent. So I like what you're saying, Cody, because if the state requires both, 4 requires the office address, 5 with your new language, you require the registered agent. And I think it's more important to have the registered agent's name in office address in the foreign state or country than it is the office address for the business. So I like your approach.
So you would say, and if the law of the company's jurisdiction of formation requires the company to maintain a registered agent in that jurisdiction, the street and mailing address of the...
Well, yeah, the name and street and mailing address of the company's registered agent.
Required registered agent. I think that's perfect. I vote in favor of that approach.
That makes sense to me too.
I mean, you're still admitting for non-US folks who may be difficult to serve, though.
They're going to be difficult to serve anyway, but you might as well know everything you can about them.
Well, what I'm wondering is if we add something, to the extent they're subject to the partnership audit rules, that we add something requiring they disclose their US designated individual.
I would say that House Bill 2191 or whatever it was pretty heavily negotiated. I think they've already got addresses and people and whoever was supposed to be identified is now part of the law. I think Cody's suggestion is a good one.
Susan, are you still on? No. Okay.
She's in the room.
What?
I think she is still here.
Well, I see her block, but I would be curious about her perspective too. So, but I do think Cody's suggestion, adding that and if language to 5 to address the foreign registered agent makes sense.
Okay, so we're gonna
We'll come back. I apologize. Could I just get that language really quick from Cody? I want to make sure I get that right.
Sure. So it's just adding to the end of 5. It would go, and if the law of the company's jurisdiction of formation requires the company to maintain a registered office, a registered agent in that jurisdiction, the name and street and mailing addresses of the required registered agent.
Sandy, that's just coming right out of the second part of subsection 4 and just changing the word office to registered agent.
Right.
And adding the name of the registered agent.
Right. Where you take out the word office and just replace it with registered agent. Otherwise, which as in subsection 4 after the comma.
Okay.
Okay, so I think we're going to come back to 707 sub 1 when we have some input from Secretary of State's office. We should still talk about 707 sub 2. 2A, except as provided in B, the foreign LLC shall deliver with the completed application a certificate of existence or document of similar import, current within 60 days and authenticated by the official having custody of the LLC records in the state. So this is basically requiring you to provide a good standing certificate at the time you register to do business in Oregon. And then B gives you an out if you can determine that you're in good standing from the website that foreign jurisdiction maintains. So this doesn't exist in ROLCA. I've always found this a little bit odd. It requires us to pay filing fees to other states that my clients don't want to pay. And all it does is give you a moment in time, right? You're registered and you're in good standing as of the date you got that certificate. That doesn't mean anything the next day. So my own leaning is to not import sub 2 from 63.707. But as always, interested to hear what others think.
I was just going to add that part B was just added in 2011. And so I assume that the legislature recently looked at this 2A and added this exception. So, maybe that was debated whether to get rid of 2A, and they ended up adopting 2B, that they get out in lieu of that. So anyway, I just wanted to at least mention this is something the legislature recently looked at.
And I was thinking 2B may be more geared towards foreign countries and jurisdictions that maybe don't operate the same way we do. And because most states will issue certificates of, you notice it says existence, not good standing. I would tend to argue, I like 2A and B. I would argue on a policy level or otherwise to put it in there. Yes, it's a snapshot in time, but I don't think we should be registering foreign entities in the state unless there's some verification that they're in existence before we accept and register them. Yes, that can go away later on, but I just feel like this ensures that people are not doing some squirrely things, like registering a company that doesn't exist anymore in a foreign jurisdiction in our state. It feels like it without this, some squirrely things can be done. So I
don't think it gives you that assurance. It tells you something, again, as a snapshot in time. It doesn't give you any assurance that people aren't monkeying with things. I'm not aware of other states that do this. And it does come up all the time because Delaware, you can't tell if someone's in good standing without paying them money. So anytime you register a Delaware LLC here, you have to get a good standing. B is only helpful. I think the one I most recently did was somebody insisted on registering an LLC in Nevada because they think that's going to be the best way to protect their assets. And so we filed them here as a foreign entity, and we didn't have to include a good standing certificate because you can go on Nevada's website and see that they're in good standing. So that it does come up a lot though. I mean, Delaware's the most obvious example.
I thought that I thought Nevada made it hard to look up much information about businesses and Delaware.
That's the one thing they'll give you.
Our American Panamas, I thought were as non-transparent as the real Panamas or near so.
American Panama. Love it.
Somebody that I've heard Delaware referred to as our American Panama. That's good. That's good. I like that. And so I didn't say Nevada. I said Delaware.
Yeah.
So I think Teresa had something to say.
Oh, I just wanted to say that I think because this was added in 2011, we ought to find out what the sort of political landscape of adding it was, because we may be obliged to keep it. I personally favor keeping it because I think it's useful to know that a company is in good standing when it starts here, because I think there is some risk that people will register a foreign LLC that isn't really a foreign LLC and then be trying to defraud people on the basis that they have an entity that doesn't actually exist. That kind of fraud wouldn't actually surprise me. I think that people you're dealing with, James, probably are real people who are trying to do legitimate business, but those are not the only ones
Yes.
who try to do stuff like this.
Well, aren't you better off with a bunch of people pretending to be a corporation who aren't? Because now you have personal liability.
If you can figure out who they are, but often the
This
problem
isn't going to
is,
help. I mean, this isn't going to solve that.
no, but it will at least keep them out if they're not real.
And that's where I'm at is, yes, it is a snapshot in time, but at least it forces them to be real at the moment that they register. I think there's some value to that.
Because otherwise you could walk into Oregon, or I could walk into Oregon and I could say, I'm going to form, well, I'm not even going to form an entity. I'm just going to register as an LLC, ABC LLC. And, I'm not going to disclose who I am. I'm registered as a foreign entity, even though the real entity doesn't exist. I'm not going to say anything about who I am. I'm going to say it's owned by PDQ LLC, which also doesn't exist. And that in turn is owned by SRN LLC, which also doesn't exist. And I'm back at the end of the chain and I'm scraping on all the money, ripping people off, and nobody can ever figure out whether that entity even existed in the first place.
That's very dark, Teresa.
Welcome to my world.
I feel like a decent portion of this statute is focused on the 0.1% circumstance. But actually, while you were talking, I looked at Chapter 60, and registering a foreign corporation does have a similar requirement.
I think we should keep it.
So, yeah, that does speak in favor of keeping it.
It's that policy thing, and we want to avoid policy issues. And I hear what you're saying, James, but the extra step of the cost, for example, of getting a certificate of existence, $50, $100, it's I don't know. I just don't think it's enough of an impediment to deviate from what looks like a policy decision by the legislature in Oregon.
So now it must give you more advance notice than I get. I'm usually filing the same day, and so we're always paying all these expedite fees.
Oh yeah. Yeah, not same situation here, but still, so it costs them with legal fees $400 or $500. It's just not a $20,000 issue, is all I'm saying.
So nowadays, getting those certificates is a lot easier too, and you get them online.
Yeah.
So. And I pointed out, Teresa used the word a certificate of good standing, and we all tend to fall back to that. But these days, most certificate of existence, which is sort of a lower level, and that's what the statute says here. Certificate of existence, not good standing.
My bad. You're right.
No, it's all you're doing, just saying this entity exists in Delaware. That's all you're getting. And that's all where the statute here is requiring is it does exist. It's not that situation where it doesn't exist and they come in and file in the state as if it does exist. That's the only information the statute's requiring.
So I think that's it for 903.
Yep.
You're moving along, James.
On to 904. A registered foreign LLC, this is amendments. Registered foreign LLC shall deliver for filing an amendment If there's a change in 1, the name of the company, 2, jurisdiction of formation, 3, one of the addresses required under the prior section, or 4, the information required by section 9035. So that's the registered agent. So for Oregon, current Oregon law, we're looking at 63.711. A foreign LLC authorized to transact business in this state shall deliver an amendment to the application for authority to transact business in this state to the office for filing if it changes. And in Oregon, the only time you file an amendment is if you change your name or your period of duration. So I am in favor of adding the stuff that we've got in ROLCA because it's ROLCA and it's also more transparency than we have today. So I think that will, I have to think that will make it easier to get through the legislature.
Yeah, I agree.
And then we have to include the period of duration because of the prior decision, right?
If we're going to keep that duration in the prior section, then we need to add it here. Yep.
Yeah.
That's 63.711.
Right. So you're really adding one category here. You're adding a 5th category, which is the period of its duration.
Yeah, I think that's reasonable.
I'll just throw out that I think current ORS does require amendment. Ultimately, if you're changing your registered agent, it's just done in a different section. So it's not like.
Yes, and some of this other stuff gets picked up in your annual report as well, but you're not required to do it immediately, which is what this would require. I will point out that 63.711 is a little redundant. Sub 1 says you shall file an amendment if you change either of these things. And then 2 says the amendment shall set forth the name, the new name, or the new period of duration. And by the way, the new name must meet must satisfy the naming requirements. I think this is all covered otherwise under ROLCA. I don't think we need to add anything.
And it looks like it's old too, so I'd rather go with a more efficient language.
Okay, I'm up to 905.
Great.
This is the one you were looking for, Valerie, when we were at the top.
Oh, good.
Where's my long laundry list of things that don't constitute doing business? So 905A, activities of a foreign LLC which do not constitute business in this state under this article include, so as probably all of you know, I think virtually all states take this non-exhaustive list of examples and leave some gray area for people to reasonably disagree about whether you have to register. This list is going to be pretty similar to what we've got today. So zeroing in on 63.701 and comparing that to 905A, number 1, maintaining, defending, mediating, arbitrating, or settling an action or proceeding. In current Oregon law, maintaining, defending, or settling any proceeding. So it's a little bit more expansive. I think ROLCA is a modest improvement. 2, carrying on any activity concerning internal affairs, including holding meetings of members or managers. In ORSB says holding meetings of the managers or members or carrying on other activities concerning internal affairs. 3, in ROLCA, maintaining accounts in financial institutions. C, maintaining bank accounts. 4, main offices or agencies for the transfer, exchange, and registration of securities, or maintaining trustees or depositories with respect to those securities. D, maintaining offices or agencies for the transfer, exchange, or registration of the foreign securities, or maintaining trustees or depositories, pretty much the same. 5, selling through independent contractors. E, selling through independent contractors. 6, soliciting or obtaining orders by any means if the order requires acceptance outside the state before they become contracts. Current Oregon law is has a little parenthetical or a little extra clause that's not there. Soliciting or obtaining orders, whether by mail or through employees or agents or otherwise. And then the rest is the same. I don't know that that adds much. I probably would lean toward ROLCA, but I'll pause there in case anybody wants to.
No, I'll lean towards ROLCA as well. And the reason is that, you know, the boots on the ground thing is less important post Wayfair. So I'm okay with the ROLCA language.
7, creating or acquiring indebtedness, mortgages, or security interests in property. G is pretty much the same, except that it specifies real or personal property. I could see adding real or personal, just to be clear. I don't know if anyone feels strongly about that. I don't think property is defined in ROLCA.
It is. It's defined in
Is it?
ROLCA. Property means all property, whether real, personal, or mixed, or tangible, or intangible, or any right or interest therein.
It's even
Thank you,
better.
Cody.
Even better.
Yep. Agreed. So 8, securing or collecting debts or enforcing mortgages or security interests in property securing the debts, and holding, protecting, or maintaining property. This lines up with H, the difference being the piece at the end of ROLCA, sub 8, the holding, protecting, and maintaining property, which I think probably folks think that's the case today anyway.
Yeah, and it makes a lot of sense because you'll have lenders who will do things like put up security or force place insurance or winterize a building while it's in foreclosure, and you wouldn't want that to be considered doing business. So to me, ROLCA's language is a real improvement to add that.
And receiverships too.
Yes.
Something close to your heart, Teresa.
Number 9, conducting an isolated transaction that is not in the course of similar transactions. And that lines up with, we actually skip one. It lines up with J, conducting an isolated transaction that is completed within 30 days and is not one in the course of repeated transactions of a like nature. So ROLCA gets away from this 30-day completion requirement. There is a comment on that in ROLCA about subsection A9. It talks about how that is part of the Model Business Corporation Act and they're getting rid of it. I think I agree with that. It's sort of arbitrary, 30 days. So I think I like ROLCA as an improvement.
I agree.
Number 10, owning without more property, going up in current Oregon law. I, owning without more real or personal property. And then 11, doing business in interstate commerce. K, transacting business in interstate commerce. So generally very consistent with current law.
Yep.
Sub 3 in current Oregon law says the list of activities in subsection 2 is not exhaustive. ROLCA doesn't say that, the comment does. And I think it's implicit with the way the lead in is worded. So I don't feel a need to add that.
I actually would prefer that we either add something saying that or that we add something in A, the prefatory language in A.
Yeah.
Well, I think it's there. In 905, it says, uses the word include, which is always a non-exclusive word.
Yeah,
whereas ORS says this is the list, and then later on adds, oh, but that list isn't exclusive. And so, I mean, ORS just as easily have said include at the front, and it would have had the same effect.
But I like to, and I think I like to be expressed. So I would suggest it include, but are not.
I agree. I think that's important to include there.
Well, I mean,
also to the top of 168, the commentary there of page 168.
Yeah.
This act does not attempt to formulate.
No. I mean, we all know this is not an exclusive list, right? But we're putting this out in the world and we're going from a statute that says this is not exhaustive to something that doesn't explicitly say it's not exhaustive. So I agree with Jeff. I think the includes but is not limited to is important to include in that top language.
Which, by the way, is a more artful way of saying it than putting in subsection 3 of ORS. It's easier, quicker, more efficient. But I always like to, when I think it's important, and I think it is here, to make what is implicit expressed so that there's no ambiguity, there's no argument.
Yeah.
I'll say I'm in favor of that too, but does Legislative Council have a preference on how they do this generally for writing Oregon statutes, whether includes is usually defined as includes but not limited to, and they're just going to do it one way or the other way based on their policy?
Well, I'm sure Sean will monkey with whatever language we propose, but I propose that we send him something that says we interpret this as being non-exhaustive.
Susan,
Yeah,
you're a resident expert. Sorry, I saw you pop up.
I'm sorry, did you say, Sandy?
Oh, I just saw you pop up about the language piece.
And I don't have a good answer. I think what you just talked about makes sense. Let Sean know what you're trying to do, including but not limited to, is supposed to be more expansive. And I've never figured out which way they do it, frankly. So just making it clear and whatever is transmitted to them that that's what you're looking at is important. And good or bad, Sean does tend to put his own overlay on anything that's written.
And Teresa, I didn't mean to cut you off. You were starting to say something.
No, I think we ought to just give directions to legislative council that we want it to be include but not limited to, and hope we get it through. But I don't think it's ultimately going to be our decision.
Sure, it's not.
So there are two new paragraphs in ROLCA that don't exist in the ORS. Paragraph B, and I have a question. I've been struggling with this and I don't have an answer. So I'm hopeful one of you has a clever answer here. B says a person does not do business in this state solely by being a member or manager of a foreign LLC that does business in this state. And that makes good sense to me for an entity. So if an entity is a manager or if an entity is a member, okay, fine. It's not doing business in this state just because of that status, and it doesn't need to register here just because of that status. But person is defined to include an individual. And there is a definition of entity in ROLCA. So why does it refer to a person?
But why would you, James, suggest that a person, an individual, doing business in the state merely by being a member or manager of an LLC? Why would it be any different between an individual and entity who is the member or manager? Why would you draw a distinction?
Well, I think the only reason this matters is whether you need to register as a foreign entity. Whether an individual is doing business in this state is irrelevant to Article 9. Like what is the impact of an individual doing business here?
Filing a tax return and paying taxes.
Tax nexus.
Yeah.
But why is that here? ROLCA is not attempting to rewrite tax nexus, is it?
No, I think this is only talking about when you need to register with the Secretary of State because you're conducting business.
No, I don't agree, Cody, because we have this question come up all the time about whether someone needs to start filing tax returns with the state.
Yep.
And that's what this provision is designed to address, is the question that we get saying, do I need, because I am making business decisions on behalf of this LLC, do I need to register with that LLC?
Well, no. Well, let's say that the foreign LLC is registered to do business in the state. It complies with our act and it registers. What this is saying is if there's an individual member or manager, they are not doing business in the state by being a member of a foreign entity that is registered business in the state. And that is very important from taxes and nexus and stuff.
Right.
So I think
person isn't only humans. Person is humans and entities both.
Yeah, and that's why I think it should be person and not entities, because I think this should apply to an individual as well.
It does.
Well,
maybe
no, I
don't understanding when
I think
about a person does not.
Cody, this is not in the current Oregon statute though. So we have this question come up all the time: is do I need to start filing a tax return if I am an individual who is a manager of an LLC? Do I need, because of that status as being the manager or the member of the LLC, do I need to start filing an Oregon tax return?
And particularly if the LLC is paying the manager a fee for services rendered, whether it's a guaranteed payment because the manager is also a member or is not, and therefore an employee, they're receiving a salary. They may be sitting in their chair in Delaware doing all the work, and yet the LLC, say, owns a piece of real property in Oregon and qualified to do business in Oregon. Does that individual have to report their salary as a manager to Oregon and pay income tax? And I would say if that person never steps into the state and has no other connection with the state of Oregon, the answer would be no. And this statute supports that. It basically says just because you're a manager doesn't mean you have nexus with the state.
Yeah, I don't know about the member thing though, because there's imputed nexus from, all the members are going to be imputed nexus from the activities of the entity.
But you know what? It comes down to the nexus rules should apply, like you're talking about. And they shouldn't be able to grab onto the fact that you're a manager of a foreign LLC that qualified in the state of Oregon.
Right. No, I agree with that, Jeff, but the member part of it, just if you're, for example, if you're, for example, a member of an accounting firm that has nexus with the state of Oregon, and you are sitting in Chicago, you're still going to have to file an Oregon return or have a composite return filed on your behalf, right? Because of your ownership interest, because you have imputed nexus through the entity.
This doesn't have any effect on taxation, guys. The subsection.
But it does, because the doing business.
Subsection C says it doesn't.
Does not apply in determining context or activities. But it's subject to foreign limited liability company, but we're talking about a member of the LLC.
Right. I agree.
Yeah, so I think C doesn't get over the hurdle that Jeff and I are talking about.
And to add to your example, Valerie, take that the CPA person sitting in Chicago owns a bunch of rental property in Chicago and has a bunch of rental income. So they have a second source of income. Maybe they have to, through the CPA firm's income, report and pay that piece of the tax with respect to Oregon, but you don't want them to be pulled in to have to report and somehow pay.
There wouldn't have to, because like rental, because the sourcing rules still apply. But if you have an active partner in a CPA firm, some of their K1 income is going to be sourced to Oregon. And so they're going to then have to file, so let's say they have rentals in Chicago, those aren't going to be sourced to Oregon, because the sourcing rules will apply at the individual transactional level. But the K1 that they got from the company, like I agree with it with respect to the manager. You have a manager who may or may not even be a member of an LLC, right?
And I agree with you. The real point I think you and I, Valerie, are both saying is the nexus and the sourcing rules should apply to that person.
Right.
And this is saying is you can't use this fact against them. You assess whether nexus and attachment and sourcing and all that stuff under those set of tax rules. And so I think that this should stay person, because it should pick up both entities and individuals.
I feel like we need to get the Department of Revenue involved if we think that we're adding a new provision to Oregon law that affects taxation.
Willie, do you have any thoughts about that? Are you still with us?
I think this is something I probably want to talk to Valerie. She deals with this a little more than I do. I'm more of the self-employed area. But
Victoria, I'm Valerie.
Sorry, Victoria. But I don't have any additional comment to it right now.
Is this something that you could talk with her about and come back next session, or our next meeting and address?
Yeah.
Okay. Because I just want to make sure that we're not expanding the nexus rules or contracting the nexus rules. I feel like the nexus rules should stay in, the tax code, not in the LLC code.
And that's how I kind of feel this. Yeah.
Well, maybe we could, if the thought is, I think we should get DOR's viewpoint regardless, but if the thought is we don't want this roll cut provision affecting taxation, we could add in C that, it doesn't apply in determining the contacts or activities that may subject a foreign limited liability company or the company's members or managers process, blah, blah, blah.
But
we can add that, make it clear.
James, I thought the whole point here was in subsection B, changing the word person to entity or entities. Otherwise, just leaving this sentence alone. And I'm just arguing that it should stay person, because person is pick up individuals and all the source of different types of entities. And I think it should pick up the whole thing. James, isn't that what you were suggesting? Place the word person, entity?
I was just asking a question because I'm not going to debate the tax lawyers, but consider this. We're in a statute talking about what does and doesn't constitute doing business for purposes of registering as a foreign LLC. So that's the context in which I read B, and I read it entirely to be talking about the fact that a member and a manager of a foreign LLC don't have to themselves register simply because they're a member or a manager. You guys are identifying this whole tax overlay that I know nothing about, but to the point that I was trying to address, person is broader than it needs to be for that purpose. And maybe it's doing two things, but it seems odd to me that it would be given, again, which section this is in and given the absence of a comment at all on B.
Sure.
That's why I'm confused.
Volumes. To me, it makes me very, it's the way the tax lawyers jumped on this and the fact that there's no comment on it makes me go, I wonder what in the world was going on when they drafted this provision.
So what I would propose, because we've got 6 minutes left, is that we stop here and that we pick up here next session. And so Willie, if you and Victoria can talk to the department folks and see if they have any concerns about this, and the rest of us can kind of noodle this. You know,
Roberta may have an idea, Valerie, if somebody can touch base with her.
That's a good point.
Yeah,
Sandy,
we actually scheduled our next meeting on a Tuesday. Reminder, it's on March 2nd. I'll make sure I get that out in order to make sure that Roberta was able to be at the next meeting.
Okay, good. Can you give her a heads up, please, Sandy, that we're concerned about this?
Sure.
And then we'll go from there. So we have March 2nd for our next meeting. Thank you, James, by the way, for leading a surprisingly contentious.
I had no idea. Mosen's going to be angry how far off Arolka we went.
So we have March 2nd, and then let's look at the following April. What does the first week in April look like? And so Wednesdays don't work for Mosen because he teaches, and Roberta
or Roberta this term, yeah.
Okay. So we could do Tuesday. That week is wide open for me right now. So does anybody have a preference the week of April 5th?
What about the Thursday or the Friday?
I cannot do the Thursday, which I wouldn't speak up except I am leading the discussion.
Well, James, just FYI, this is April, so I don't know if we'll get past your session.
Oh, fair point. You're right. We should be done, I think.
Well, just to be on the safe side, I don't mind Friday. Would Friday work for people?
That'd be April 9th.
Yep. Any objections?
Yeah, and the Fridays are never going to be an issue for law professors unless they're teaching 1L classes, which they aren't.
Okay. I mean, it works for me. Does anybody have a problem with it?
So April 9th?
April 9th.
Okay. I'll get it out there.
Sounds good. All right. Yeah, Susan?
I was just going to say, thanks, everybody.
Thanks, Susan.
Yeah, thank you all. I really appreciate all your hard work on this, and I'll look forward to seeing you next month. All right. Thank you.
Everybody.
Thanks, everybody.
Thanks.
Hi, everybody.